And I guess I want to ask, following up about the field, it seems to me you don't necessarily lose even under the enclave theory, because I understand the field preemption argument to be kind of a Clearfield Trust, Kimball Foods. This is an enclave of uniquely federal interests, but even if that's so, all of that means, and Boyle kind of finesses this question, but all that means is that the federal court would adopt a common law rule. It doesn't necessarily mean that the state rule would be, that there would be no liability, I guess is what I'm saying. So if that were the case, we would still have to decide what the rule would be, and we could decide to let state law apply as a matter of federal common law, right? And if we look at the Federal Tort Claims Act and you see that the combat activities exception doesn't extend to independent contractors, you might say, well, it makes sense to allow liability to remain even if we're doing it as a matter of federal common law, right?
That is certainly correct, Your Honor. So there is a line of cases that say, as a matter of federal common law rule, we're going to adopt a state law rule here. But I think the simplest way here is to just read Boyle as it is, and it's about a contractor who does what the government
No.
does.
I understand that. I guess what I'm saying is I think you could win even if even if we're looking at it as a matter of, listen, the Constitution carves out war powers and that sort of thing as an enclave of uniquely federal interests, which it does, right? If you took that line of analysis, I don't think you necessarily lose even under that line of analysis.
We wouldn't, Your Honor.
Do you understand Boyle then? Sorry, can I just finish?
Yeah, sure.
Do you understand Boyle then to create a very narrow kind of preemption that's not constitutional, that really is just about the conflict of contract terms?
Yes, that's how we understand it, and that's what the opinion in Boyle said as well, because Boyle carves out two hypotheticals where you're dealing with the government contract.
Yeah.
Correct, and a stock helicopter example as well. So that clearly shows that contractors, or Justice Scalia envisioned a system where contractors are still subject to state law liability.